This is an appeal on the matter of the King on the application of Ocean 100 Limited and the New Forest National Park authorities.
Sorry, just get the accident prone member of the Constitution organised here.
No,
Apologies that we're sitting a little late.
I'm so sorry to see my lady's injury.
I don't anticipate, but if I need to stand up and walk around, because I've injured my back as well, so if I need to get out and stretch, then you'll have to excuse me if I say we have to rise for a few minutes and we just have to walk around.
Entirely understand, my lady.
But I can assure you and everyone behind you that I'm perfectly fit to hear the case. I hope you haven't got a second today.
My lady and my lords, I appear for the Appellant, Ocean 100. My learned friends, Mr. Finlay KC and Ms. Parry, appear for the National Park Authority, who I think throughout this hearing will be referred to in shorthand as the MPA. The court will have the core and supplementary bundles and the authorities bundle. There's nothing further that's needed in terms of paperwork that we're aware of. My lady, what this case concerns is the revocation of a very valuable lawful development certificate some 15 years after it has been granted, in circumstances where none of the persons involved in that grant are any longer around or alternatively have a recollection of what had happened, where a large amount of the material which was considered and the information which was considered at the time is no longer available and not known to any of the participants, and where the handling of this revocation by the MPA is seen, and will explain why, to be unfair and given an appearance of bias. What I'm going to do in terms of the sequence of my submissions is to go essentially straight into them. Start with ground one, which is the absence of evidence on which the conclusion could have been reached. Then turn to ground three, which is looking at the assessment, both in the MPA, they want the judge says about it, before the judge says about it, and then pick up the slightly more sort of process points in terms of 2, 4, and 5. So material not disclosed to us, 5 for the fairness issues, and 5 the bias issues. And then there's a degree of overlap, as the court will perhaps appreciate, between the various issues, but I'll explain as I go through it where the legal errors arise within that. So, my lady, turning to ground one, which is the need for evidence upon which a decision could be reached, and the notion of judicial review that there is no evidence on which the authority could have reached its decision. This one is well established. It is very clear, a high hurdle to say that on the material which was available, they could not have reached the conclusion that the trigger for revocation arose. And also, I do not say that in any situation where there is some degree of missing evidence, that it is impossible for a local authority to lawfully conclude that the trigger for revocation has arisen. However, in this case, there is such a absence in terms of evidence and information missing in that process that the authority could not have lawfully concluded that the applicant, Mr. Cox, either made a false statement which was material or withheld material information. The essence of that is that the one representation from Mr. Cox, which we do actually have in terms of any direct reporting or information about what it contains, is the application form itself for the certificate. There were certainly 3, with indication of a 4th communication from Mr. Cox that we know from the papers, which were decisive in having the certificate issued, and we don't know what he said. The context, of course, is that this is an application process which went on for a year, where the MPA solicitor, Miss Mutlow, raised concerns, was minded to refuse, and was persuaded in due course by the information she received that the certificate should be issued. What that information was, we don't know. What we know to be missing is, I'll just briefly list these, the information gathered by Miss Young, the planning officer, on her 28th of August 2007 site visit. The information.
Sorry, can you give me the date again?
28th of August 2007. And we find that date on the computer record. The 10th of September memorandum from Miss Young to Miss Mutlow, which we simply don't have that at all. We then know that there were 1 or possibly 2 written communications from Mr. Cox in May and June 2008, because there's a reference in, first of all, information being provided in Miss Mutlow's memorandum of the 12th of June 2008, page 57 of the bundle for the notes.
Was that the supplemental bundle?
Oh, the supplemental bundle, my lord. So, tab 23, page 57. So the first paragraph in Mutlow refers to copy the further information that was supplied, do not provide a great deal more clarity. So there's 1 written communication there.
The earlier reference you gave, Miss Young, 28th of August, that's 2027.
That's 2007, my lord.
2007, I beg your pardon. And we haven't got to 27 yet. Is there a reference for that?
Yes, my lord, the reference to that is tab 11.
Thank you.
Which is the data system blocking.
Yeah.
My lady has that. Page 34.
Yes, thank you.
I appreciate it. I think my Lord or Justice Holgate is working from the papers, and the Scott I think are working. I'll give it, if it helps, I can give the tab and the page number.
Please could you, in that order, every time.
My Lord. So that is tab 11, page 34, with the record of the site visit. So we were looking at tab 23, page 57, which is the 12th of June memo from Ms. Mutlow referring to further information being supplied by Mr. Cox, which was apparently we don't have that information. The next page within that, so tab 24, page 58, is Miss Mutlow's attendance note of the 24th of June, and that says that Mr. Cox had provided further limited evidence, which coupled with the conversation I had with him. Now, certainly an inference from that, I would say it's an irresistible inference from that, is that between the 12th and the 24th of June, Mr. Cox has provided further information in a written form, not necessarily. So it's not necessarily the case that there's reference to the material, but there's an indication that there's a second submission of written information. There was a conversation between Mr. Mutlow and Mr. Cox that's referred to here. We don't know what information was conveyed in that beyond what we see in this memorandum. And that refers to, I would have liked detailed evidence, but she concludes on the balance of probabilities.
So what you can't identify, because you don't have it, is anything in these further interactions which contradicts or supersedes the 4 words in box 6 or 9, which is in the CLEUD application. So to that you're on absence of information rather than being able to demonstrate positively what you said was you.
Well, at this point I'm dealing with the absence of information. In terms of what's said at box 9, which is a reference to the overall site and going beyond the initial application for the storage site as being a touring caravan site. That is a conclusion which the referred to as CLEUD officers, so Ms. Young and Ms. Mutlow, who are dealing with the first application, end up agreeing with.
Yes.
So that's just, I'll come on to that in due course because it comes on ground 3, but that is not a statement which we accept to be wrong. The officers in dealing with it actually found at the time was correct.
Because they issued a CLEUD control site.
Because they issued the certificate, having looked into it. In terms of what else the officers knew, the point as well, was there information which could have steered them away from that conclusion, which they didn't know? What we have is the reason for investigation. I'll come on to that in due course in terms of the comment about activities. So the officers knew something was, other things were going on and needed to investigate it. In terms of whether false statements made or information withheld, we need to know what Mr. Cox said, what he didn't say, in circumstances whether or not that's material. What we don't know is what the contents of these 1 or 2 written communications were. We don't know what it was he said to Mr. Mutlow on the conversation recorded on the 24th of June. We, again sticking with this memo.
This is the one at page 58.
At page 58, my lord.
Yes, thank you.
We don't have the letter from Mr. and Mrs. Higgins that's referred to in the second paragraph. There's, we understand it with Naples, there's a reference elsewhere to them having made an objection in September 2007 to the lawfulness certificate application. So there's 1 or 2 communications from Mr. and Mrs. Higgins.
Can I just make sure I'm keeping up with you? That's a reference to caravans and boats. Is it on page 58? And it's reference to storage.
Yes, my lord. That's all it says.
Just taking the whole overall flavour of this document, it starts off in the first paragraph talking about storage caravans.
Yes, my lord.
And it ends up by suggesting that the officer is likely to grant a CLEUD.
Yes, my lord.
But there's no discussion in this document about caravans being on site for human habitation.
No, my lord, that's right. The position on caravans being on site for human habitation, the application covering that, my lord may have picked up that the application does straight away. The application form, which we find at tab 9, page 28. Starts at page 28, come to Cox. Page 29, so next page, is asking for a description of what the application is for, what the existing use is. So section 6. So simply describes storage of flooring caravans. Then going over the page to page 30. The point which is the subject of the MPA's criticism is section 9. More what existing use describe fully where touring caravan site and touring caravan store is referred to. The application form we find at page 32.
This is the plan accompanying the application.
Accompanying the application, my lord, that's right. So this is what Mr. Cox submitted, and the court can see that it's been stamped. So 9th of August. That shows the storage area in red, and that is just to pick up the reference. If we go back to page 31, section 13, list of documents, and that refers to the location plan and the storage area in red checkers. So we can see the storage area first in the application.
Does the document explain the other notation?
No, it doesn't, my lord. There's no other reference to that.
Obviously, we can see it continues to the east.
Yes, my lord. Perhaps 2 points that follow. One is that in terms of the overall site, which ultimately receives the certificate, this location plan only shows part of it. There's a little bit that's cut off on the western side, and there's some of it that's cut off on the eastern side. It is the case that the area given of 2.57 hectares is actually the same size as the overall
So
site that's
where does that
certified.
appear? Oh, that's on page 32.
On page 32, my lord.
Yeah, thank you.
So the application as submitted seems, and this is a point which we made during the course of the revocation process, has been our interpretation of the documents, and emphasise, of course, that we have come to this site many, many years after the event. So our understanding of what went on in 2007, 2008 is based on the documents which we have remaining. So we've been in a position of interpreting what was going on, but the application was registered, and if the court goes, please, to SB 11, tab SB 11, page 34, which is the electronic record I mentioned earlier. So this is part of the MPA's records, and that describes the proposal as land for storage of touring caravans. And within the box on the left-hand column, it identifies case officers as young, and in the right-hand column refers to a site visit, the date of the 28th of August, which is the date I mentioned earlier on. So that's being described as land for the storage of touring caravans.
One can say with confidence about the application is that the storage area is cross-referred to the plan and is clearly in reference to the red checked.
That's correct, my lord.
Full stop.
Full stop.
Full stop. Everything else, at least on your submission, is speculation about why there's grey cross-hatching of the rest of the site, why there's area of the sites there, and so forth. Sorry, influence, you would say not.
Well, the application, the application is described originally by the council, the MPA. I'll come on to how the position moves on in a moment. The application is described originally by the MPA as being for storage of caravans, and that was prompted by a variety of enforcement inquiries. Running from March onwards. Perhaps don't need to take a call to detail of that.
I'm sorry, I may have, forgive me for interrupting you so much, but the storage area referred to in the computer printout must be a cross-reference back to the application form.
Yes, my lord.
Where the storage area, the red crosshatch bit says storage area.
My lord, that's right. Yes, my lord. And the point I was about to make was that the outcome of the enforcement investigation, which have raised issues about a number of matters going on the site, had been that the council's enforcement officers had asked for suggest a lawful development certificate being applied for in respect of storage of caravans. And we pick up the references to 2 points to that. One is tab 5, page 23, which is a letter of the 16th of April 2007. Mr. Cox. And the third paragraph in that is referring to the storage of caravans. And then the next reference maybe is to tab 10, page 33, which is a letter of the 23rd of July 2007. Again relating to the storage of caravans in the second paragraph. And it looks like from the date stamps on the lawful grant certificate application, whilst the certificate is a signature signed as being the 4th of July, the date stamps were received the 9th of August. So at the time the 23rd of July letter is sent, the authority doesn't seem to have received the application. So The reason I draw attention to that is that the issue which was being raised was storage of caravans and seeking a certificate to that. The use as a campsite, or particularly for caravans, appears not to have been particularly contentious within the MPA. I'll just give one reference to the enforcement reports. So if the court goes please to tab 28, page 64. This is a enforcement report from a relation, in fact, to a later report. The court will see the reference at the top of the page, 08, so 2008, enforcement investigation. And
the index says this is about April to August 2008.
yes, my lord, it seems to be it may well be there's a rolling report or a rolling reference. The officer,
Well, the last paragraph records on the 4th of August.
indeed,
Yeah.
my lord, and the officer refers in the first paragraph to a site visit in March.
Then third
No.
paragraph, one in April.
Yeah, so the March reference may well be given, the open material may well actually be 2007. Because it's what is it then said is consistent with what we know Mr. Cox has said in March 2007. There's then the third paragraph down, the reference, as my lord has mentioned, to a site visit in April 2008. And particular attention to is the next paragraph, which begins the concerns raised. And what the enforcement officer says there, the site has been known as a campsite and is documented in NFDC, that's New Forest District Council. They were the local planning authority until the National Park Authority was formed in, I think, 2005, thereabouts. So documented in NFDC correspondence in 1996. So, my lady, the reason for taking the court of those documents is just to explain how, from what we understand, how the application came about was prompted by enforcement and prompted by concerns as well not the storage of caravans was lawful. What wasn't a subject of concern is like the lawfulness of a caravan site in terms of site used for occupational caravans, or as referred to in this note as a campsite. Now, what then happens, go back to, so the application is date stamp is received on 9th of August.
Is this the only document which supports that proposition? No concern about the campsite?
No, there's something else which also some assistance about it being acknowledged overall as a camping site. If my lord goes to tab 25, thank you, page 59. This is a plan, as you can see, prepared by the MPA. It's dated at the bottom, 3rd of July 2008. And that's not ultimately the plan that goes on the certificate, different map base, but
Did you say 59?
page 59, my lord.
59.
59. And that looking like it's OS map base has a has a notation of camping site.
I'm not sure where this takes us because it doesn't say what sort of camping, nor in the other document. It doesn't say the extent of it. But why are we going into this? Because we know there's CLEUD granted for both storage and caravan site, and it's not permissible to use section 137 to revisit the merits of that, to revisit the propriety of that decision.
Definitely. And my lord, well, this is part of what gives the NPA's case for revocation one of its problems, which is that it's criticising the reference to touring caravan site on the application form. That is allegedly the false statement to allegedly withholding is not producing information which undermines or could undermine that conclusion. That's what the NPA is complaining about. But the NPA's officers at the time concluded that that description was correct as to what the planning use was, because they issued a certificate for caravan site and caravan storage. So the
But my question is, we don't know how they got there, nor do we need to know, do we? For the purpose of section 137?
well, we do for these, but first of all, to
And they may have made a mistake.
they may well have made a mistake, and that the NPA no doubt, well, both from the later documents, the NPA does not like the certificate.
That's a different point.
They want it, but that's by the way.
If they made a mistake, because I understand your solutions, forgive me for being so slow. Two things follow. One is you can't then argue that the words in the application form are material, because they don't obviously apply to the whole site, but the certificate is for the whole site. Is that correct?
Yeah, so they weren't. They weren't in the
This
application.
may be a question for
Yeah.
the other side.
They said weren't material when the application was submitted, but it was a narrow application. The application subsequently, in one way or another, gets amendments to be brought.
And your main point from the last 15 minutes is, although we know there were other interactions, we don't know what was said.
We don't know what was said. What we do know, my lords, is that the NPA, particularly Miss Mucklow, knew of other activities being referred to, and on the basis of that was seeking to then also make a decision. So if the court goes to tab 14, page 39, that's Ms Mucklow's memo of the 18th of October. And refers to Miss Young's memo of the 10th of September, which, as I said, we don't have. Then, under the paragraph no evidence, Miss Mucklow under 1 refers to the contrary issue raised on the face of the file, i.e. whatever activities are ongoing on the site. So, in October, the NPA is aware that there's some other issue. Now, precisely what the file is isn't clear. It looks, when we were dealing with the revocation at the NPA stage, it was looking more likely, because we couldn't see anything else, that it must be the enforcement file. It well be that it is the file on this particular application. What that other information is, we don't know. It's something, whether that is from this young site visit, whether it's enforcement material, there's something that indicates there are other activities, which then prompts a question as to whether or not the certificate should be issued. And Ms. Musgrove then writes to Mr. Cox at tab 16, page 42. On the 14th of November, and says in the second paragraph, you have applied for a waterfront certificate, confirmed the use of land in question of storage of touring caravans and as a touring caravan site in excess of 10 years from the date of the application. So that's the first reference we have to the application encompassing the wider site. Now, of course, it is perfectly permissible for an application to be amended. We don't know why Miss Musgrove put it in that wider terms, whether in any other communication or she was reading it differently. But that's the point at which the wider site first gets referred to. And of course that's in advance of the 2008 communications between Mr. Cox and Miss Musgrove and also Miss Young. And we find a reference to the communication with Miss Young at tab 22, page 56, which is a letter of Miss Musgrove's to Mr. Cox on the 9th of May. That refers to a conversation with Mr. Cox and Miss Young on the 29th of April. So again, we don't know what was said at that point. So this is a situation where the majority of the communications between Mr. Cox and the MPA's officers dealing with the certificate, we do not know the contents of. As I said, we don't know what beyond the very short statement Mr. Higgins has said. We don't know what the Parish Council has said when we consulted.
Can I just confirm if I understand the position? Is that the next page is a memo from Liz to Julia, Julia to Liz, Julia Musgrove to Liz,
Yes.
in which she refers to the nephew just referred us, and then says, I attach a copy of the information that was supplied. We don't have that information.
We don't have that one, no. And at that point, she says she's inclined to refuse. And then there's, on the next page, page 58, there's a conversation and looks like more information. Maybe, I said, a little bit unclear. More information provided by Mr. Cox, and that persuades Ms. Musgrove to that certificate. So in terms of what the MPA officers knew what Mr. Cox had said to them, we don't know what was said. We don't know what Mr. Cox added about what had been going on, although we do know that Mr. Musgrove had concern about other activities on the site and some information she did have. And ultimately Mr. Cox was able to persuade her to give us sufficient information to grant a certificate. whether something is material as a false statement or information withheld is affected by whether or not that is subsequently corrected, and it's also affected by what the local planning authority knew at the time. Because if the authority knew the correct position, and the fact that they didn't get it from the applicant would not in that situation matter. They're going to evaluate the information. And evaluate the application. So this is bringing down more to the point. The NPA needed to have evidence upon which it could have reached a positive conclusion that there had been materially a false statement or material information withheld by Mr. Cox. And we have so many gaps in the material that that is a conclusion which an authority could not reach. We don't have, perhaps as final answers, though, we don't have a list of what the documents were that were in the file. So what I've drawn attention to are documents or information which we know was received, simply don't know whether there is more communications which simply aren't referred to in the documentation that survives. But in terms of what we know was received, which we don't have, the majority of communications from Mr. Cox, we do not know what was said.
So there are two, sorry to keep
No, that's all right.
I'm trying to find my way into this. There are two possibilities. Either the MBA made a mistake, granted a certificate in relation to the following site, in which case there's no basis usable for saying that they did so on the basis of a false statement by Mr. Cox, because we don't know enough about the process by which it wasn't a mistake. And again, your submission is there's no basis for saying that it was rightly done because of what Mr. Cox put in the application form. The application form is clearly limited to the small area, so there's got to be something else that we don't know what it is.
Well, and it was wrong. Well,
that's if it's not a mistake.
If it's not a mistake, they've got it right. Then they've got it right on information, some of which the NPA is now saying they didn't know, but they've got it. They made a judgment. The important point is the question whether they got it right. There's a matter of judgment to be made by the NPA officers at the time, with their knowledge of all the sources of the site as to what was going on, and there can be a degree of judgment as to whether particular activities constitute degree of judgment as whether or not particular activities constitute a use of land, and what parts of the site are in which particular planning use. That is a matter that individual planners, those making those decisions, may take different views on, having seen the site and looked at the evidence that's available. The evidence which was at the time available and which is available is evidence which sort of leads to this conclusion that the officers, Miss Mucklow, assisted by Miss Young, could have reached on what we know could have reached a conclusion, which they did, which was that the site was either part of caravan storage and the remainder in use of the caravan site. That was a conclusion that was reasonably open to them. In that situation, the current complaint of the MPA that Mr. Cox made a false statement when he said this was a site for caravan storage and a caravan site falls away. Judgment was reached by people there at the time.
Use that again.
Judgment was reached by the people who were there at the time. And it does amount, in that situation, to really the MPA disagreeing with the decision which its own officers have taken some 15 years.
You didn't say it was a caravan site in the application.
Sorry, what?
Oh, you did, yes. Touring
Yes,
caravan
box
site.
nine.
yeah, 9.
Site and store.
I mean, presumably you have to read boxes 6 and 9 together. They're both asking about uses, and 9 is saying when they're talking about you. 6 says don't describe it in general terms like industrial. Be more precise. So to make sure someone has not misunderstood, 9 says in effect make sure you say all the uses.
Yes, what
And that's where he says caravan site and storage.
yes, and what Mr. Cox
So on that, I mean, this is part of the application 9, isn't it?
well, it's part of the information given in the application. The application.
Well, my question was: is it part of the application? Is it what they're applying for?
My lord, it's not. It's not what is being applied for.
You say what's applied for is confined to 6.
Because if we go back to, so it's tab 9, page 29, box 6 is described fully the exact nature of the use, which if the application is for an existing use, storage of touring caravans. Tab 9, box 9, is talking about if there's more than one existing use
On the land.
Yes, and Mr. Cox.
Sorry to interrupt, but just going on to the letter you took us to the 14th of November to Mr. Cox, page 42.
Yes,
sorry,
please.
Applied for a lawful development certificate to confirm the use of the land question has been storage of touring caravans and as a touring caravan in excess of 10 years as of the date.
Yes, Mary, that's what is said there, and that's the first time that the application is described as encompassing both uses.
That does seem to me, I'm who is an expert in this area, but Mrs. Mutlow, who is the senior solicitor, is regarding it as an application.
Yeah, she is taking.
Picking
Well,
up Lord's point.
yeah, my lady, Miss Mutlow on the 14th of November is taking the application as being wider.
Well, if that's not right, what is box 9 doing? Why is it there?
Why the answer is there in box 9, my lord.
It talks about the land and it says if there's more than one use, tell us about it.
Yes, and
It's not gratuitous, is it?
Well, what Mr. Cox is doing there is referring to the use of the wider land, certainly. Because we can see.
Sorry, forgive me. It says the. And what does the land mean if it doesn't mean the application site?
Well, my lord, that is like the question is put.
Is it a very difficult one?
Well, it's it's Mr. Cox is filling in this as far as we can tell about the professional assistance. The section 6 refers to that's what the application is for. Section 13 refers to listing the documents, and
Can I just draw your attention to 3, box C on page 28? Address or exact location of the land. Describe here and enclose 5 copies and ask for a plan.
yes,
It says it must be a red boundary.
Yeah.
So the plans, as is common in planning, is part of the application as well.
it is, my lord, and it doesn't show.
No, but the
The
red
totality
line
of the-
stops at the edge of the extract from the OS. I mean, could anyone in their right mind think that the boundary stopped at that point and ran down the side of the drawing?
What is
I mean, there isn't a red line down this. In fact, if you look at it, look at the western boundary. The red line is shown running there to the west of the boundary. It runs up to the edge of the drawing. But
Yeah.
is one to infer that there's no boundary between that one and the northern boundary? Particularly when you read it with 2.57 hectares. I mean, that doesn't seem a very difficult point.
my lord, the perhaps ultimately doesn't take us too far on when we come to the final decision. But my lord, the way we've interpreted the material is that and this is the way the NPA should describe it, is that
On the computer record.
on the computer record, it's on the parish council briefing note, which was also dated the 28th of August, as an application for certificate inspector storage of caravans, and that is consistent particularly with section 6 of the form and the identification of the storage area, and the fact that the overall site isn't actually shown on the plan. Now, certainly it is the case that by the time we get to November, Miss Mufflow is viewing the applications relating to the whole site and relating to a caravan site use as well as to caravan storage. So at that point, that is probably be seen as an amendment that's proposed. Of course, we don't the question of how many of this material are missing. The NPA are looking at this as the whole site, and they're looking at the caravan as being a caravan site.
This is deliberately pure speculation what's coming. You've got an enforcement problem about storage of caravans.
Right.
The enforcement was specific about storage of caravans.
Right.
You've then got an application which says if the application is for an existing use, you describe the full nature of use and issue, not the general description. Storage of touring caravans, number 6. Then you're asked about if there's more than one existing use on the land and so on and so forth. At that point it says touring caravan site and touring caravan store. But then he goes on to explain in box 13, 5 ordnance survey location and storage area in red checkers. And we know that's the small bit.
Yes. Yes, my lord, well, that's sort of how this application comes about.
That's how the application comes about, and subsequently, in circumstances which we don't know, the officer expanded the concept of the certificate and eventually gave the certificate to the whole of the site rather than the storage area, just the storage area.
Yes, my lord.
Can you go any further than that?
Now, in terms,
I fully accept what my lord says about the significance of 6 and 9, but that's the context in which it comes about.
that's the context, my lord. Of course, whether the description in 9 is accurate, as including a touring caravan site, becomes significant when the application is broadened. and these are also the certificate on the wider site.
It's sorry, forgive me if I'm mistaken. It's accurate on any view once you read it in context. This is an application of, as made, it's an application in relation to the storage,
Yes,
which is the checkered area. But he also refers to the fact, which was not contentious at the time, that it's used as a touring caravan site.
yes,
And for my part, that's where I am at the moment. And I may be in a state of complete confusion, but subsequently, by a process which I think, as Mr. Findlay can explain it, we don't know, a certificate is issued for the whole site.
yes. And in terms of that certificate being issued for the whole site, the officer concerned is cognizant of some issue about certificates and goes through, it becomes a lengthy process to verbally satisfy to issue the certificate.
If we go back to box 3, I mean, presumably we have to read this document as a whole. That's the classical way of approaching planning applications. Is that right, Mr. Holgate?
Undoubtedly, well, so
If we go back to box 3, what is box 3 describing as the land? Can box 3 be read as confined only to the checkered area?
yes, my lord, it can be, because what is the box 3 asks is the address and the exact location.
Of the land to which this application relates. My question is, reading the question and the answer together, can that be confined just to the red checkered area denoted for storage?
Yes, my lord, it can be, because if
Even though it says the boundary of the land must be edged in red?
yes, and first of all, in terms of the address and in terms of the address being given.
Well, my lady very kindly did ask the question, which was embedded in mine, which I asked. I did ask earlier on,
Yes.
but I defer to my lady.
Yes. Well, I'll take both of the reports.
It's the same question, Gooseberry.
Sort of a bit of a pinky and perky
well,
going on.
well, there's two aspects to the answer.
Yeah.
But if I can put it that way, a slight freedom of the fact that we're not defending what was drafted here,
Of course not.
but we're trying to understand it. The address of a site may well have a situation where on a particular site a certificate of application is for part of it, but the address of the site is going to refer to the totality of the site. Where is this place? What's its address? So that picks up most directly my own interest. To go to my lady's question about the site, which is the site plan.
We were looking at, sorry, perhaps I shouldn't have chipped in. We were looking at 3. Address or exact location of the land which this application relates, which the Lord said, and there's Vernon Dene as above, referring back to the address.
Yeah.
But then it tells us that you have to describe on the OS map, appropriate scale, boundary of the land, which presumably must refer back to the land to which this application relates, must be edged in red. And then, of course, we've confusingly got the OS map that doesn't quite cover it all.
And then, my lady, we have the plan at 32.
Yep.
Which is prefaced by what the comments at section 13, with the plan at 32, which clearly shows a storage area. It does, as the course pointed out, have a red line on those boundaries. It doesn't show the totality of the site, because it's missing off land within the totality of was site, totality of the site or land. I'm trying to, it doesn't necessarily follow.
Perhaps I can help you out, Ms.
application.
Harwood, because I'm actually conscious that we're taking up a huge amount of your precious time dealing with what is effectively your very first point on your very first ground. I mean, it is not really what you're submitting, is just the fact that we're having this conversation tells you just exactly what was not known, and that we're all in danger of entering into exactly the sort of speculation which you said was
and that the
danger.
and the documentation which we do have is in something of a mess in terms of
Got that far.
what was submitted. Ultimately,
I mean, your point is that we don't know that there was a lot missing. We don't know what they actually knew. We don't know how they reached the decision, and that's where you anchor on your submission.
Firstly, in terms of round one, that there is so much missing.
I think we've got that point.
That they couldn't possibly reach the conclusion. My lady, can I turn then to round three, which is looking at the assessment, and there the focus is on the part one report, which is in the supplementary bundle. Patient the tab number.
About 28.
It is tab 128.
Sorry, only 100.
Page 504.
Could I just ask? I'm sorry, I'm asking. This report refers to a pack.
Yes, no.
Now,
Which bits are the pack?
where do we find the pack?
Where do we find the pack? If my lord goes to,
If you want to come back.
no, I can pick that up. Yeah. My lord goes to first page 514, which is a list of the papers. The reference to the pack is Annex 4.
Yeah, that's partly why I asked the question.
And that, the problem with that is
Tab 100.
Yes,
It's
we've got the
something
letter
from
at tab
tab
100. I think I got as far as that. I gave up.
Well, perhaps rather than taking up your time, is if someone could, you haven't got a junior, perhaps you're interested, if someone could just give us a list of what's in the pack and the references where we'll find each item in the pack.
yes, well, it is. So the
Did it include a statement by Mr. Avery, for example?
it included
The 16 appendices.
Yes, my lord.
Okay.
included the draft statement.
Well, my lady, the pack is described at page 351 under the heading "the pack."
Ah, thank you.
Ah, do it. 351.
351 says it's the same document. It's effectively Mr. Avery's statement, the local residents' statements, and some Mr. Avery's statement plus his appendices and the satellite image and photographs, various photographs.
Thank you very much.
It's tab 100, 351.
Do you say 3 or
Yeah,
2?
351.
351, which is the end of Mr. Avery's letter.
Yes. There's a heading in the just above the middle of the page which says "the pack," and then in written terminology there is what the pack included. And I can tell my lord and my lady, lords, that the pack included at that stage did include all the appendices, and the appendices weren't included in full in the report that went to the Park Authority.
What I'm trying to get a handle on is what was before the authority.
Yeah.
So, and I get confused because the next, I'm sure it's my fault, but the next tab, 101, is an email from Mr. Avery to Mr. Lewis on the 18th of January So, in my simple way, all I was
Yeah.
looking for was
No.
the pack that was before the members.
Yes.
The standard way of approaching judicial review.
Yes, my lord, the principal bottom of the pack is to have the draft statements inquiry, which is at tab 96.
Was this
first
recorded?
fold in the supplementary bundle.
It's the annexes at
Page
the back.
2, so page 321.
And what's that?
Sorry?
Sorry, what's it, 321?
At 321 is a statement of Stephen Avery dated January 2023.
You call it the draft.
And it describes it as latest draft. There isn't a
That's it.
revised version.
Is that the version that went before the members?
That's correct, my lord.
So
And that's the
the
version
option
on
of it.
which
Thank you.
was
So can I just be clear? I'm still on 351. So the pack is defined as the statement of Mr. Avery together with images.
yeah. So what it's
And the resident statements.
there's a resident statements. So right in if
So that they're not, those were part of the pack, they're not just fed into Mr. Avery's statement. Excellent.
so
I don't want to take up time, but at some stage it'd be useful just to have a note which resident statements, which page in the bundle. But I'm sorry to eat into your time. And the photographs also, because there are some photographs in the bundle later on. So sorry.
my lord, in terms of the parts of the pack that were put in front of the board in October 2023, it's the draft statement which is at part 96.
Well, we can drop the word draft, can't we? You told me it was the
Yeah.
same as the final version.
Is it because, well, it is that document.
Yeah.
It's not changed. It still contains the redactions.
Right.
The appendices to that, as we've got, are not put in front of the board. What the board,
Can you give us a list of the appendices?
this appendices at 322.
322.
Yeah.
So they could have asked for them if they wanted.
Were they given those or were they just given the list?
They've given us, well, they were given the statement which had the list and they weren't given those appendices.
Oh, thank you.
They did have statements from various residents. They apologise, those are some statutory bundle. What we'll do is prepare a list of where those are. So the court does have those.
And the board had those.
So
The board had those.
the board had those statements.
And there was, just so we see what was before them, there was also a presentation, I think, by Mr. Avery, which had photographs.
Yes, and that was
What form was the presentation? Is it a slide deck or was it freestanding?
there's a PowerPoint presentation, and you have that presentation at tab 129, page 515.
Thank you.
Now, this is the presentation is put up on screen by Mr. Avery in the part 1 session of the meeting. And that does include some other photographs and whilst we have it to and the only part of the certificate application that's provided is at page 529, page 529, presentation. Which is section 9. And also the declaration, which is at the end of the certificate. So in terms of the debate we've been having about section 6 of what the plan was and so on, the board didn't have any part of that material. Now, the extent to which the board had any of this presentation in advance, something would say, if the court goes to tab 125, page 495, you see an email from Mr. Avery to the board members of the 13th of October. And in the first paragraph, he says he's attached some of the slides for the Vernon Dene item, which will be included in the presentation. Now, we don't know which slides those were.
This is a point about advance notification.
About advance,
as opposed to what was undoubtedly shown at the meeting.
yes. My lords, as we what we have, the slides we looked at earlier are the ones which were shown in the meeting by Mr. Avery. We don't know which ones members had in advance.
Does this simply retain?
So,
Does this simply retain the paper copy? Why can't you just open the attachment?
well, we're getting various documents at varying stages in these proceedings.
I'm just questioning your. You've told us that we don't know which will form part of the selection that was sent on the 13th of October, but it was an attachment to an email.
Yes.
So on the assumption that someone's found this in their emails, the attachment should be there.
If the attachment is still there, it would be possible to find that out.
I'm not sure it's going to change the result of this case, but
but of course it's an email from within the NPA. So
All right.
So that's what the board have in relation to the pack, and you will also see from the back of the board report, this is page 514, that's tab 128. The various independent documents of those certificate of lawfulness. We have the caravan site license and the enforcement of sergeant and bundle deduction. We discuss the pack and we will refer all the references to that. And then as 5, which is a letter on behalf of the owners, we find that.
By the way, you just draw attention to the site license. That's under the 1960 Caravan Sites and Development Act, and you draw attention to section 3 of that act, which prevents a site license from being granted without a full planning permission. But section 197 of the 1990 Act deems a CLEUD to count as a full planning permission.
Yes, my lord.
So can I take it that the site licence boundary equates to the red line 2.57 hectare boundary?
Yes, of the certificate.
Otherwise your site licence would be unlawful.
Well, unless it was a smaller area, but it's not.
Yes.
It is on the site. So, my lady, the Jones Day letter, which is Annex 5, that is at tab 120, page 454. And Annex 6, the authorities letter of the 3rd of October is at tab 123.
123.
At tab 123, page 486. The human rights consideration document isn't in front of the court. We're taking human rights in these proceedings. So, my lady, that's what the members had in terms of what's been submitted in the report. I turn then to.
Could I just ask, on my, I'm looking at the name of the page, to just before and just after, and there's various sentences and words highlighted in red. Were they highlighted for the members? Is that how it's presented to the members?
No, my lady. What we have, the document at 452, which is a document that starts, it's a tab 119, starts at 446, and the covering email to that is 445. Now, this goes into the bias points, but it's helpful to explain
Well, I just, at the moment,
Yeah.
I'm interested to know who's highlighting this is. And was that highlighting in place for the purposes of the members reading this document?
No, my lady, because what my lady's looking at is the draft of the Parliament's Court.
Does the yellow represent suggested changes which came from Lord Manners?
That's correct, my lord. So,
It's just that they're all
So-
in connection with in support of the application to revoke. They're
Yeah.
all pregnant.
so my lady, Mr. Avery sent a draft.
I knew that, and this is the draft that was sent to Lord Manners. And these highlights are where Lord Manners, if I might put it like this, wanted things beefing up a bit.
Where he suggested changes.
Yeah.
For example, the classic example is 1.6, page 446, line 3, the word sound is inserted
Yes.
in front of argument. I think you've all read this.
Yeah.
Yeah.
Yes.
Yeah. So that and that many of these changes don't find their way into the final report. That change from arguable to sound arguable is in the
Yeah.
final report.
Thank you.
If I turn to the final report, so that's tab 128, and starts at page 504. I want to deal with, this is in relation to ground 3, the assessment, how the NPA reached that conclusion about the trigger, and the flaws within that, most of which were agreed by the judge below. And I deal with the point where he found that their reasoning was sound, conscious that the respondents noticed that seeking to reopen the notes as well. The analysis is principally starting at page 510. Whilst it's headed expediency of revocation, it is actually also dealing with the trigger for revocation. Section 4.3 summarises the authority's case for revocation.
Was this developed more fully in Mr. Avery's statement, which was given to the members?
To some degree, there's more material.
Well, this is a summary. That's why I asked the question.
Yeah,
The innocent question.
so my lord, there's some more analysis in the draft statement as well.
In the
In Mr. Avery's
In
draft
more
statement.
detail.
yes, that's that. I'm just wondering where it was.
Yes, my lord.
Okay, thank you.
But also some of the analysis follows through in the remainder of this section 4.
Yes, thank you.
So
do I take it, sorry, picking up from what the law says, if this is a summary of what is in Mr. Avery's statement on the analysis point, so do we take it that if I was a board member, I'd be reading Mr. Avery's statement in conjunction with the final report?
yes,
And they actually were a piece
the
effectively.
5 sort of lines which are taken in paragraph 4.3 are in Mr. Avery's statement and follow through on that. That statement wasn't updated from January 2023, so the various developments and representations aren't picked up in Mr. Avery's statement. But it is, in terms of what the reason is it is behind completeness in this report, in Mr. Avery's draft statement, and also the authority's letter of the 3rd of October, which is referred to in Annex 6. That's a response from the authority to the final representations on behalf of Ocean.
3rd of October letter, we find that
We find that, my lord, at tab 123,
thank you.
page 486.
Yeah.
Yes, that's right, my lord. And in terms of those points, the judge below at paragraph 163 of his judgment rejected 5 of those reasons as being legally unsustainable. So it's the final, sorry, 4 of the 5 legally unsustainable. So it's the final 4 bullet points. Now, we adopt his criticism of so I'm looking at the report to the board, page 510. And that is the final 4 of those points are criticised by the learned judge at paragraph 163 discussion.
Sorry, paragraph
163 report.
He describes them as being unfair.
I'm sorry?
He describes as being unfair.
Yes, I would. What he now he's right to
well, it varies, doesn't it? Grazing and pasture use as a freestanding point is really clutching at straws. Does he explain why it's really clutching at straws?
not
I mean, The simple point I think that's being put, maybe right, maybe wrong, is that when you're looking at the CLEUD, it was certifying 10 years continuous use in the sense explained in the authorities.
Yes, I would.
So some people were saying, well, for at least part of that time, a substantial part of the land was being used as a paddock. See, for example, the area of photographs taken on the site, which enabled those fields to be used for the grazing of horses and so on, and not for caravans. So why is that? If that's the nature of the argument, for the sake of argument, why is that clutching at straws?
Well, it's in the context in this case of, as the judge would have seen it correctly, that other uses and other activities are being raised and being dismissed.
Or like the mini crusher?
Mini crusher, which is a point which Mr. Avery's statement relies upon.
Yeah.
It doesn't, which is, my law's notice drafts Mr. Avery's statement, page 334, paragraph 527, is the mini crusher point by Mr. Avery. Mr. Avery doesn't pick up at all within that the planning enforcement team found that wasn't a breach of planning control.
Yes, but I wasn't asking about that.
But we mentioned that. So we have this, what maybe in the court's mind was that we have this consideration of other uses because of various enforcement allegations being raised. None of those other uses being identified. In terms of question of paddock use, there is a reference in Mr. Cox's interview with the enforcement team in April 2007 to levelling, to crushing the rubble, to
I thought there were two different things. One is the crusher for use for rubble, and the other was a stack of material which had to be levelled. That didn't have to be crushed as rubble, did it?
Well, the reference which we have in tab 4, page 22, which is the authorities enforcement officer noted in the conversation with Mr. Cox in April 2007, where there's discussion about the crusher and what Mr. Cox did was taking it out on the site, was using the crusher himself on the fields of various property, proves only left mounds of dirt and rubble to currently crushing and levelling to turn it back into a paddock for his horses. So
that's talking about a future use.
that's talking about future use.
That's talking about use of paddocks in the past.
He's not there doing that.
No.
And in terms of the paddock activity, where Mr. Avery deals with in his statement. Tab 96, page 333.
By the way, just on 22, forgive me for interrupting you, just the penultimate paragraph, the field adjacent to his property, the property seems to be the bungalow, is used as a camping and caravan site.
register.
Then he talks about caravan storage.
Yes, so reference to the camping and caravan site does seem to be to the Vernon Dene site rather than to land outside that.
Yeah. Sorry, Luke.
Sorry,
You take this to something else.
Yes, I think the evidence is historically a certification by the Camping and Caravan Club, which would have allowed up to 5 caravans.
Suppose they used to be about.
There's discussion number of caravans on site. I'm going to look at what the NPA is saying in terms of the paddock use. We go from Avery Estate, page 333, which is at tab 96. And within that, there's page paragraph 522. So Mr. Avery is then referring to righted area photographs. Totally 11 of those taken on various dates. He then suggests that on 4 of those 11 photographs, they appear to show grazing animals in what he refers to as the eastern paddock. And we can see what is being talked about in terms of paddocks and so on. We go to the aerial photographs, which we find at tab 129, which is the presentation, and within that the sequence of aerial photographs starts at page 531. So it's north to the top, helpfully. And first in the 1999 photograph, we can see a number of items on the northern side, and then in the northeastern area, a variety of caravans, some of which have got awnings attaching to those. We can see at the centre, bottom, a clump of caravans which are positioned very close together. So those are caravans which would be being stored.
It seems to be roughly in the cross-hatched area.
They're roughly in the cross-hatched area, I was right. They're stored because they're too close, both in practical terms and also in safety terms, to be being occupied in that configuration. And that's what's sometimes being referred to as paddocks. Suggests it's not the correct description. The uses are the fields between the top and the bottom, with potentially a western field, a central field, and an eastern field. And the court will see on that intrusion by a number of caravans into the western, one into the western field, and several stored into the southern field. If we go to 532, we can see caravans intruding on those, both the western and the central, just a bit to At the top of those, the stored area seems to be slightly greater, and a number of caravans along the southern edge of the eastern field. 2003, somewhat similar, slightly more caravans in the least visible in the eastern field. 2004, not seeing any caravans in the eastern field, some intruding into the western.
Sorry,
field.
just tell me, why are we looking at each of these photographs?
Well, just hopefully to explain the context of the point being made by the learned judge about the paddock's point being touching the straws. What Mr. Avery's statement is doing is actually referring to some animals being seen in the eastern field in some 4 out of 11 of the aerial photographs which he's assessed. It becomes a matter of evaluation, emphasise a matter of evaluation by the officers back in 2008. But this isn't a situation where the evidence was showing these fields being full of animals, whether it's livestock grazing or it's horses being kept.
But if these photographs are remotely representative, and I accept that they're snapshots each one,
Indeed.
no one who visited the site for 5 minutes could imagine that the whole of the site, apart from the storage area, was being used as part of the site.
Yes,
So where do we go from there?
so
Where do we go from there?
well, my lord, visiting the site, what would have been seen is caravans, certainly on the northern side, and the particularly touring caravans in the northeastern area, caravans in the southern part of it. You can see from the ground level photographs of a variety of other sort of items being around. We don't see an agricultural or horticultural use in terms of animals being there, at least in the photograph. What we have is a matter of judgment to be reached by the officer at times of what is the extent of the caravan site. Is there some other uses or use which is taking place on that site? And that is, and this is where the problem comes for the MPA going back over this 15 years ago. That is a matter that is preeminently a matter of judgment from someone who has actually seen the site and understood what was going on at that time. That is something which Ms. Young, who's as the planning officer, certainly did a site visit on that. The council, the MPA, accept that aerial photographs, exception of what aerial photographs would have been available at the time. It's also a matter that the council's enforcement officers in 2007 and 2008 were dealing with a variety of allegations on the site and didn't find that there were any other planning uses. So to understand the point being made by the MPA, the alleged false statements or withholding of information, and the way in which the court below deals with it, the context, of course, is what would have been known to the Law Certificate office at the time of what was going on there. And what all that material points to is fairly a matter of planning judgment as to what their uses were. My lord is right to say that the aerial photographs don't show caravans over the totality of the site. the caravan site will include the land that's used in conjunction with caravans. What is going on where there isn't a caravan site? Is that being occupied as part of the caravan site? Is there some other use? Well, none of the officers dealing with the time are finding another use. So this is the problem that the NPA case for revocation goes, which the High Court essentially is pointing to, is that these are matters where they're reaching conclusions basically about disagreeing with the officers knew at the time, and in doing that, they have to not pay attention to what the officers knew. The point we make, which the report doesn't address at all, is the criticism of this muckless identification of activities on the site. We say, and we were saying at the time, that means that the officers knew that there were some issues about other things, and clearly got the information to resolve that. So there's no basis for revocation. We don't know what the board makes of that because there's no answer that's offered to the point. The criticisms which the learner makes are of those 4 points are in some right. Finish off on the 4 points and I'll come back to the final one where he does back up the council case. The complaint by the council that, by the NPA, that they weren't told how many caravans were on the site by Mr. Cox. Whether or not that is factually correct, we simply don't know what he said on that. The NPA chose to issue a certificate without putting the number in. It could have issued a lawfulness certificate which said lawful use of 20 caravans, 50 caravans, whatever they thought was appropriate. They chose to issue a certificate that doesn't say that. That's not withholding what it seems as being entailed to the decision. The point which Mr. Justice J does differ from this is the first of the bullet points at 4.3, which is about whether large plot site was not used as either a touring caravan site or for the storage of caravans. Now, that is in a sense the flip side of actually, well, where you go wrong is because it's the flip side of the NPA's point is rejected. If there's no other planning use of those parts of the site, pushes aside quite rightly the other issues, then that point, unless it's just that there's no planning use at all, that becomes rather implausible, then the caravan site is what remains, and that is very much a judgment for the planning officers at the time as to what was in that caravan site use. Having rejected the NPA's complaints about other uses, what you're left with is the obvious conclusion that the NPA were right in 2008 to say the Holgate site was a caravan site with a limited area for caravan storage. There may not be much going through inference because there's not much going on possibly in those fields, but anything that is going on is really in planning use terms be seen as part of the caravan site. The grazing areas, interiors and caravan sites. That's very much a matter of judgment. This goes to, in the end of the day, because issues have been recognised by the responsible officers, and they had knowledge of the site, you would expect what the NPA's case of revocation amounts to is simply differing rather than from those officers, rather than being able to establish that those officers were giving materially false information or material information was withheld from them, and that wasn't resolved, corrected in the course of that determination process.
Thank you. Turning then to 164.
I'm sorry.
You were then, I think, turning to 164, the judgment. And you stripped
Yes,
away the other parts, the judge.
Yes,
the
in
judge
terms of
said
what-
bad points.
Yeah.
Presumably there's 2 points there from your point of view. One, whether he was right about whether it was a good point, and secondly, whether it was appropriate or it was possible just to strip out one issue when it was being presented to the board as a cumulative group of issues set out in full detail.
So I didn't quite catch my lady's one. I apologise. Kind of.
I think my name
As a planner would put it better.
no, it's entirely me.
It wasn't an insult.
No, but I think the question is, was that first point being presented to the members as a freestanding point? Was there any basis for putting forward that first point if you stripped out the other ones?
Yeah.
And I was just going back to Mr. Avery's draft, or not so draft, statement to see if that's how he was presenting it to members, and no, I can't see that.
No,
It seems to go hand in glove with the site was being used for other things.
Yes, my
That's exactly
my lord and my lady are absolutely right that it's not. It isn't one of those situations where a recommendation is being put to say, well, we've got 5 points and any of those are good enough.
Yeah.
It's all being put together, and there is certainly between the first 4 points, a significant interrelationship. It's very, and that is perhaps that's where.
So to be fair to the judge, in 164, he says there was apparently convincing evidence from third parties that this representation was. So I won't find it in Mr. Avery, but the judge is saying you'll find it in the witness statement.
And my lord doesn't.
Or witness statements
Yeah.
or third parties.
Yeah.
Perhaps in representation.
What is the judge talking about when he says, I repeat that on 5th of April, Mr. Cox, when he made that claim, he said in terms that the touring and camping site was on non-appeal.
Well, my lord,
If he said that, sorry, let me explain my confusion. If he said that, what is the basis for saying that there was a material misstatement in accordance with the first point? What am I missing?
yeah, I think what the point the learned judge is seeking to make is to suggest that Mr. Cox was saying it's only on the caravan site is only a limited part of the site. Now, that is not what Mr. Cox was saying. Of course, there's the interview with the enforcement officers, which is a tab.
Sorry, you're saying the judge is in error in 164 in that last sentence when he said in terms the touring caravan and camping site was on one field.
Well,
Are you saying Mr. Cox never said that?
yeah, if what he means by that is the point that the learned judge is making, previous sentence that on which then refers back to where it covers the whole area, 5th of April 2007, Mr. Cox never made that claim. If we go to the record of the interview, page, which is tab 4, page 22.
Okay, so we're now on the meeting at 5th of April.
Yeah, so I appreciate we've looked at this. We've looked at this a number of times. It's a reference, the reference to the field in the middle of the second sentence, the field adjacent in the 3rd paragraph, and then discussing on site the amount of caravans.
And so that's where the judge got
His last sentence.
his last sentence.
In terms of the field,
Because Mr. Cox was saying, actually, we use it for this, we use it for that, we use the other, was doing this, no longer doing that. In the field adjacent to the property, we use camping and caravan, certified by the Camping and Caravan Club.
yes, and what is
How many fields were there?
well, my lord, we take that what Mr. Cox is referring to is the totality of.
But this is really important. Forgive me, this is really important
I appreciate.
because it forms part of the context for the application. Application is made to the MPA, who have already had a discussion or have a discussion with him, in which he says something which is diametrically opposite to the first bullet point, the first of the 5 bullet points. And my question, which again may be one for Mr. Findlay, is, given that and the other stuff that's been discussed this morning, how can anybody say that what appears in box 6 is a material misrepresentation? Because you've got to read it.
Yeah.
If you try to interpret it in a way that makes sense, you interpret it in context. That's where I am at the moment. Struggling.
My lord, there's no material misrepresentation by Mr. Cox. He is, when we come to the application, leaving aside precisely what the application is for, section 9, he's referring to the larger size. In this, the authorities note of the interview, he's referring, or we can see, to the totality rather than to the western paddock or the central paddock or the eastern
He
paddock.
says the field adjacent to his property. I know adjacent can have a flexible connotation, but
His property is at the bottom left of the plan.
There was at the time a sort of bungalow.
A bungalow.
So he's referring to.
And that makes perfect sense because
Yeah.
the storage area is at the far end of that field. If the field is divided by what looks like edges or something which cast a long shadow.
Yeah. So the storage is sort of further on to the east behind the bungalow. He seems to be referring to the totality of that, and that is also the way of understanding section 9, and that becomes.
so that supports the certificate, the whole of the totality of the field. Is that the way you're reading it?
Yes, Mr. Cox is referring to, so that application refers to the totality.
And
In
that's
terms
he's
of where
talking
he says the caravan sentence, leaving aside what the application is for. He, in this note of his interview, again seems to be referring to the totality, not a particular field within
All right, well, we've got your
that
special
site.
on that.
But so the view of Mr. Justice J, paragraph 164, that Mr. Cox in that interview hadn't read the claim that it was the whole area, is a misreading of Mr. Cox's interview note. So now, so I'll just say one more I need to pick up on. This particular point, the final point I'll deal with on the ground 3 is relates to the speculative nature of the judgment below. And if I can go please to a couple of references to the section that starts at paragraph 144 of the judgment. Which is a question of consideration of knowledge.
Sorry, question consideration of
well, question of consideration of knowledge, and then the analysis of so 144 the bottom, so the bottom of the page, then just talks about inferences. And goes on to analyse a number of points over a leaf. The first point to note, of course, is that what we are concerned with is the judgment was reached by the MPAs on the revocation as expressed in the documents which it produces that it meets the reasons in the report. Particularly when it comes to factual findings, the ability of the judge to uphold the decision by drawing inferences which weren't, or conclusions on that which weren't made by the MPA, suggests is really not available to them. That's simply a point that is obvious.
Maybe I've misunderstood. It's the thrust of this section, which includes 144 and then the following paragraph, is meant by the judge to reconstruct what might have been the reasoning of the officer who granted the CLEUD.
It's an attempt to reconstruct what the to infer what the officers thought, and particularly.
Why is that relevant under section 127?
Materiality.
Yes, I think that is.
Materiality of what was said or not said in the.
Well, it's one thing to try and ascertain what was said, what was not said, which you feel about under 1937. But why does the decision maker need to infer what was the reasoning of the decision maker under CLEUD?
Well, the only way
Why do you need to do that?
Yeah. Well, the reason it seems to be done in the judge's analysis leads is to be aware of hoping a conclusion that the officers who were dealing with the specific application weren't aware, or when Mills puts it, they didn't have their minds on the matters they needed to, and so there was a material misleading on the basis that Mr. Cox didn't say something. And so when you're putting it like that, it seems to me it is a fair way of putting that, shows how remote that is and how difficult an speculative exercise it is to do that. So, for example, if the court looks please at page 150, the,
Sorry,
This-
paragraph 1.
about 150.
I'm sorry. Thank you.
Which is the site visit which Miss Young carried out in August 2007. Learned judges, he recognises there's no note. He's speculating entirely as to what Miss Young had in mind, and then he goes at paragraph 152, which is continuing this question, a probability that Miss Young was thinking about section 6, so the reference to caravan site storage, rather than anything else. Now, I think that's it's simply not part of the NPA's reason. That's an easy way. For instance, the NPA didn't even mention science. It's not a it's not an influence which the learned could rely on to say, well, actually, the CLEUD officers missed this issue because they weren't told about it. Most of the CLEUD officers sort of having a knowledge of what there was on site.
I got lost at this point. The last sentence of 150, it's after all talking about the site visit on one day in August of 2007. It's not reading the 10-year user period, for example. And it's saying, that is right, the possibility that Miss Young ascertained on the day of her visit to the touring caravan site was limited, not so, cannot be discounted. I mean, so what? What does that tell you about whether anything, about whether the qualifying conditions relying upon 1937 are satisfied in terms of information having been misrepresented in the past or withheld? I'm pretty lost.
I've got a suggestion. If the conclusion in 150 was anybody who visited the site would see immediately and be conscious that the site was not as a whole being used as a caravan site, it goes directly to the materiality of box 6, which, if one looks at it on its own, appears to be saying the whole site is used either as the red hatch storage or as a caravan site. And the first bit is that it was a material statement to say in box 6 that the whole thing was being used as a storage or a caravan site. And so to my way of thinking, if it is right, if you look at the consistency of the photographs, if it is right that anybody attending for 5 minutes with an interest in the CLEUD would see that it was not being used as a caravan site for the whole period, then it goes directly to materiality, and whether the judge was entitled to say that it was arguable that there was a material misstatement. That's my suggestion. May not be any good. May need a bit of refining.
I mean, in a sense, it's the judge. Well, it's the judge seeking to explain away the point which the NPA simply don't really recall, which is that Miss Young did go to the site in connection with the certificate application, and the ultimate outcome of the process was a decision by, as much advised by Miss Young, that the whole site was a caravan site. Now, if they were capable of being right in that conclusion, then the complaint of the NPA that there was a false statement, that it wasn't the whole of a caravan site, falls away. What Mr. Cox said in section 9 was perfectly correct. So
that's a different interpretation and a different contextual analysis.
But the only way it then gets the significance of this discussion by the judge about what Miss Young may have in mind is to try and explain away the fact that having been on site, she didn't say to Miss Mutlow, well, actually, a large part of this clearly is in a caravan site. That's what that section is about, and it is entirely speculative with respect to the judge, not part of the NPA's analysis at all. They don't mention the site visit, and is really leads the judge to uphold a decision which is unsustainable on the way in which the NPA analysed it, coming up with another explanation of events which is not given by the NPA at all, and as my lord's indicated, it's far removed from the question which the NPA had to direct themselves to. Was it that Mr. Cox said or didn't say, if you can tell, and what's the significance of that? So that's
Complete ground 3.
that completes ground 3. Pleased to say.
So then moving on to your 2, 4 and 5.
Yes, my lord. And that is the process concerned with this decision making. Round 2 concerns documents which the NPA did have at the time of the revocation, but which had not been produced to enable Ocean to deal with those. And just one, this one I can take quite briefly. That the
The judge
enforcement.
said they were good. It was good enough.
So
The judge said it was good enough.
yeah, and it wasn't good enough in those circumstances. What the enforcement case discloses. So if we go to SB, so to tab 6, page 25. Is that the enforcement officers in April 2007 had closed the crusher allegation. There wasn't a breach there. Now, given that we've touched on it, one of the points we relied upon by Mr. Avery, that there was that element of the activity. The fact that enforcement said that sort of planning use in itself is significant.
And basically, in a nutshell, the note is saying nothing's going on the site referable to the crusher. It's stored there, it's taken off and brought back. All the crushing goes on elsewhere.
Yeah. Or there's a little, in terms of the interview, a little bit of crushing to tidy up the site.
Well, yes, but that's something, as my lord pointed out, was in connection with a particular operation on the pad.
Yeah, what's going on the site.
So again, we mustn't lose sight of the fact that the 10-year user, this crusher basically is going elsewhere all the time. It's crushing.
Yeah.
So it's not rocket science to see why they came up with that.
Yeah. And then two other points to pick up are firstly the NPA's case management record, which we have at SB 11, page 34. So we have looked at. That's the one which gives the site visit date of the 28th of August. That had been provided to Lord Manners as long ago as December 2020.
Page 11, did you say?
So, Lady?
Did you say page 11?
I'm sorry, tab 11,
Page 34.
34. Which we looked at. We didn't have that, which confirms the site visit point.
But we have nothing about what happened on the site.
We don't.
Just say what you're lacking is just the fact of the site.
There was a fact of the site visit.
Okay, I've got it.
final I want to pick up under this head is the July 2008 OS drawing, which is tab 25, page 59. We've looked at this already. That's the one that refers to the camp as a notation of a camping site. Drawn across what's referred to as a paddock. Again, that is supportive of what has been going on. Those were the situation where we're dealing with what was going on a long time ago. No one involved remembers what's going on ago. Ocean will not have anything to do with the site at that stage, nor any of their people. The information which was available is information which was coming in the most part from the NPA. So it was critical that we got the material which was available and not all that was. My lady, that's my say on ground 2, and then turn to deal with grounds 4 and 5. There is an overlap between fairness and bias in this case, although of course the legal basis for the error are separate, but greatly with the bias case we might be concerned with the way in which we were treated very differently from local objectors, in particular Lord Manners and Mr. Lewis. So that criticism sounds both in the appearance of bias and the test on that is not being contentious before, it's where a fair-minded and informed observer, having considered the facts, would conclude there's a real possibility of bias, and also in terms of the fairness of how we dealt with it. I'm just conscious of that we're running into towards lunch, but what I seek to do is try and sort of explain some of the context of it and see where we can then find a convenient point, if that helps. The context of the bias case is that the learned judge's conclusion, I would find this at in the judgment of paragraph 127, is that if he says Mr. Avery had been the decision maker, he would have, the learned judge would have found apparent bias. As he was critical, as he was not, the allegation is sufficient to mount an allegation of apparent bias. What the, I know the NPA is differing on the interpretation of this part of the judgment, but what the judge is saying is that Mr. Avery's conduct gives rise to apparent bias, but because the decision is taken by the board, that doesn't bring down the board's decision. To run to the end of my submission, which may help in context, on that particular point, the context is that Mr. Avery is writing the report to the members. He's the sole planning officer dealing with that. He is reaching conclusions in that report and in the patent material and so on matters of fact. What was it that Mr. Cox said or didn't say? What was or wasn't going on the site? What conclusion is there to be drawn about whether the CLEUD officers knew the matters which the enforcement officers knew at the time. Those are matters of fact which go to the heart of the NPA's conclusions on the trigger. Those are matters which Mr. Avery is advising the NPA on from his senior position as the senior planner within the authority. And they are matters which the members of the board are not only expected, of course, to take great attention to his report, but also it's very difficult for them to differ from that. First, of course, it's not their job or task or really time to sort of go through all the evidential documents. And secondly, they don't actually have all the evidential documents. I've shown the brief extract from the application form, which is in the presentation pack. They are heavily reliant on the advice which Mr. Avery gives. And if Mr. Avery in giving advice, he's doing so from the appearance of bias, that infects the decision which is reached by the board. It taints the board's decision.
How?
Sorry?
How?
Because the board is being asked to adopt, and does adopt, because it adopts the part of the report as the reasons, Mr. Avery's conclusions. And the risk with bias and the appearance of bias is that those conclusions are influenced by, in this case, the predetermination and the preference towards the stance taken by.
Sorry, those are two very different things.
Yeah.
Predetermination means you have a closed mind, as opposed to having a preference. It's made very clear in the authorities.
And my lord,
How are you putting it?
in this case, it can be properly put in both for this reason. But
There's no problem having a preference. The case law says authorities and public bodies can have a preference.
Well,
what they can't do is have a closed mind.
well, it's that's my response.
It's a different concept to that of a ground bias.
Here, what I mean by preference is a bias towards the position taken by.
So it really is bias, or appearance of bias.
Yes, in that sense, rather than where preference is used in the sense of a councillor saying, I quite like high density to buildings. That's my preference, but I'll then judge an application with that in mind. Doesn't mean the council's always going to approve it. That preference, of course, is legitimate. Here, what we have, and we'll see through the process, is, you say, going down a process where he is working hand in glove with Urbana's, Mr. Lewis, towards getting a particular result once the decision is taken. We would have to go down the revocation route. There is predetermination which says that looking at that too, you think that it's not likely that our representations will be treated in a government balanced fashion. And it is that bias towards how the objectives are dealt with, how they are treated, how their representation is
It'd be a long stretch to say even if they were indeed Mr. Avery's predetermined view, I could say the same of the board, which is why I don't.
No.
It's much easier perhaps to look at this in terms of bias and to ask, well, what is the effect of the apparent bias on the part of Mr. Avery in the rest of the process?
Yes, the effect is that the board are given a report which, even if the conclusions reached are possibly legitimate conclusions that could be reached. Conscious, we've hit the clock. That conclusions could be reached on those particular facts. The bias gives a real risk of a bias towards a particular conclusion. So a particular conclusion, Mr. Cox didn't say this, that he didn't disclose that, but this wasn't going on, that the information held by the enforcement officers didn't reach the lawfully relevant certificate officers. Even if those individual conclusions might on their own be ones which a decision maker is capable of being reached, where there is an appearance
ones that an unbiased decision maker could not be reached.
could not be reached, but where there's an appearance of bias, even those conclusions are undermined by possibly that conclusion has been reached, influenced by bias. And to take us to another example of perhaps in the judicial context, making even more sort of a Pinochet case of the risk of apparent bias by Lord Hoffman. No doubt Lord Hoffman's opinion in the Pinochet judgment, in the Pinochet case, was impeccably written and reasoned and so on, and a fair judgment in the circumstances. But
that was a connection with justice.
A connection with justice, but I will make it as an illustration of the point.
Is that a convenient one?
It is a convenient moment.
Thank you all very much. 2 o'clock, please.
Court rises able.